state has to step in.
saying that private property was outside the scope of 39B.
That's all.
But we are saying that there must be some some parameters laid down.
Yes.
Otherwise, the logic of Ranganath Reddy and Sanjeev Kok is an individual is a part of the community. Therefore, the individual is a part of the community. Since the individual is a part of the community, everything that is owned by an individual is community ownership.
So
this is like a hark back to Ayn Rand's, Atlas Shrugged and all that line of Fountainhead. And
no, that's true. That's well. The reason why I would refrain from making any suggestions about what the scope of resources is only because of this. Very honestly, much like the founding fathers were, they had the wisdom of a future day in their minds when they made these provisions. I think if we were to take the thought forward, if today we were attempting to lay down strict definitions, it could come back and boomerang on us on a future date. If 30 years down the line, one interprets a judgment which is rendered today, which says, for example, that anything within the house which is meant for the personal use of individuals within the home would be excluded from this scope. And if, say, in 5 years' time, we're in Bangalore and there's no water in the lakes and there's no water anywhere, but I have a tank or I have a borewell in my house, and the state needs to commandeer that so that the water is then shared with everybody, they will use this 9-judge judgment and say, I'm sorry, this stops you from coming further.
No, it doesn't. It doesn't. It only makes sure that you don't have the immunity. That's all.
No, but the question
you can still justify a law.
Correct.
You can still justify a law for requisitioning private resources on the ground that it's in the public interest.
Correct, but because of
immunity is not available. That's all.
But the lordships are very familiar with the fact that if somebody were to file a writ here, they'll be told to go to the High Court. They will go to the High Court. Meanwhile, people are dying of thirst, and they will file a petition there, and they will be told a 9-judge Supreme Court judgment holds the field, and that poor judge will have his hands shackled, so he will have to decide in favor of the petitioner. I'm saying today, I'm just off the cuff, this is an imagination of mine, and my imagination is not stretched far enough to think of all possible resources which could or could not, in the age of AI, in the age of cryptocurrency. My friend Nipun Saxena wants to address your lordships on that, on the fact that property can have so many different resources, because I think there is a distinction between property and resources. I think we will fairly admit. So resources means there is some utility coming from that property, which is going to be employed for a particular purpose.
Don't confine the...
Correct. My suggestion is, since the question is only, can you enter the private domain? The answer should be yes, you can. To what degree, what can be touched? I think best left to smaller benches to decide when that question arises. Because yes. Sorry. Yes.
Sorry.
Please, sir. Yes.
Example that you gave of somebody having the right to manufacture vaccine.
Yes.
See, that would definitely be part of what we understand as material resource.
Yes, it would.
And can we not think, taking a cue from what fell from this Chief Justice on literature?
Yes.
May I describe you as Mr. Howard Roark and say that you are visualizing a world where, under the provisions, the material resources can certainly be utilized for a situation of the kind that you have visualized.
No, I agree, Manoj, but the difficulty I find myself in is one of syntax. When we use the phrase material resources, are we saying that any particular resource so identified is a material resource for all time to come? Or, because in English, the word material has two definitions. One is tangible versus intangible. That is one definition of material.
Value.
The other is value. So,
of utility and value.
Or utility or value. That's the other definition. Now, if I'm using that definition, something which may not have been a material resource yesterday may be in a critical situation a material resource today. The question is, how do we define on a particular date what is that material resource? Because these are, your lordships,
today and tomorrow.
Yes.
To answer to that, material resources to subserve the common good.
Correct.
Today it is not. It is a material resource, but it is not to subserve the common good, because everybody has water.
Yes.
But today I am the only one who is having the borewell with water.
Correct.
So now today material resource becomes to subserve the common good.
Are right. Your lordships are right. Definitely. Because the only question that I have in my mind is that when we start looking at resources, is there a possibility there are resources which may not be treated as material resources today? Meaning the source value definition. Not having that today, but it may have it at a particular day, or vice versa. But the question is, do we have to go down that path for the purposes of this reference? This reference really calls for only do you enter the domain or do you not? If you do enter the domain, then the state has to justify in a given case.
You tell a manufacturer of semiconductor chips
Yes,
situated somewhere in Taiwan
yes.
that, well, you manufacture semiconductor chips in India because India needs semiconductor chips. But sorry, this is a material resource of the community. We might just take it away. He's
We
going
have
to say,
possibly
sorry,
been-
I don't want to invest in your country. This is the level of protection which you give me.
I agree. Your Lordship and I have perhaps been reading the same book if it's chip wars. So it's, no, I fully agree. So the question is, I'm sure democratic decisions will be taken by legislatures and governments about going that far. The only question is, do we have a deficit of faith in that system that everything needs to be laid out and defined in a very, very stark fashion today? I feel for the purposes of the questions that are referred, it's a limited question that is being referred because a question has been raised saying, can you go private? Really, for the purpose of this case, I don't think anybody is doubting that ownership of physical property, land, tenancy, etc., would be beyond that. If they do, they will raise that questions before a bench once it's answered here.
But the sister wants to say.
Yes,
Wanted to say, see, it is not just material resources per se.
yes,
It is material resources of the community
yes,
and it is for the purpose of distribution.
correct.
Now, if you read this in the context of clause C,
Yes,
where it speaks about the operation of economic system,
yes,
distribution is an aspect of the economic system.
yes,
So it
absolutely.
should be read in that context,
I fully agree.
so that the material resources of the community is
Yes.
so distributed,
Yes,
so that ultimately the operation of the economic system does not result in the concentration of wealth and
absolutely.
means of production to the common detriment.
I
So
endorse.
both
it.
these have to be read.
I endorse it fully.
So
It has-
question is, if a person invests,
Yes,
puts up a huge factory,
Yes.
starts production,
yes,
tomorrow it cannot be said that it is going to be taken away for the purpose of distribution to the workers.
no, my lord,
That is not the aim of that. Be as such.
perhaps it's not, and your lordships will decide so in a particular case.
It cannot be, you see, only private resources also to be included also. It may not be.
No, the
you see.
question only, in my view, that
A private resource is
Yes.
not a material resource of the community. Then the right to property, various other rights vis-a-vis real property.
yes.
What happens to those rights under the common law and
So-
the statutory law?
So I'm glad your ladyship referred to that. The reason why these phrases are used, and I've mentioned that in my other note, is that all these phrases come from Roman law. And that's the origins behind how the founding fathers inserted these provisions in. They also have been borrowed from the Irish Constitution. But in Roman law, when they talk about ownership, and I've given a chart showing the different types of ownership, there's the type of ownership of property which can be taken, which can be distributed, and which can be utilized. And there's the type of ownership that you can't, for example. They refer to it as res nullius. Wild animals, for example. Nobody has ownership over those. Forests, waterways, those kind of things. Nobody has ownership over it. The state doesn't own it. Nobody owns it. It is available for everybody. And the state in public trust holds it. So I think the only question, the way I would convert that question is to say that if this state is being told today that you cannot employ 31C for any property that does not belong to the state, then I think that is a very extreme view. The minute we are permitted to embark into private ownership of any sort, it may be a company, it may be land, it may be cars, it may be trucks, it may be any one of these things. For example, any natural disaster takes place and we need to requisition something, whatever it could be. It could be medicines, it could be food, it could be any one of those things. Food, for example, one could claim it's for personal use. I need it, but we have starving infants, perhaps fatherless babies who are left after a flood. We need to take care of them. Surely these powers can be employed for those purposes. It's a little difficult now to stand and determine all of those. I'm saying that if you can go into the private sphere, that's all. That's where the question stops. If you can go into the private sphere, where we can go, in what circumstances, because Article 21 survives. Article 21 is available for that challenge.
But the only problem
Yes.
is that you can't go as far as Ranganath Reddy, which says an individual is a part of the community That
Perhaps
everything of an individual is that of the community.
Perhaps not. Perhaps not.
That may
That's
be a
true.
little
That's-
far-fetched.
and like Mr. Dwivedi
There may
said,
be certain vital aspects of a resource of an individual
Correct.
in which the community has an interest as well,
correct, correct.
which is a resource of the community.
I think that I think would be
Data,
fair.
data, or,
Absolutely.
or the airways, spectrum.
Correct. All of those. There are many examples. I'm sorry.
etc.
Yes.
Prior to distribution
Yes.
is always under the particular Land Acquisition
Land-
Act or
yes.
whatever,
Yes.
or a Nationalization
Correct.
Act.
All of those are available.
Yes.
Yes. But
And it is after giving a compensation, fair compensation.
correct. No, if your lordships consider intangibles, for example, intellectual property,
Yes.
both the Patents Act and the Copyright Act has compulsory licensing provisions, 84 and I think 31 of. Now, compulsory licensing provisions permits the state to step in and take what is your intellectual property and employ it. Take it as a compulsory license and ensure that it is employed for a larger purpose. There was a discussion, I think, yesterday about cancer cures. Anything of that sort, for example, which could be utilized. Now, there surely it can't be said, 14 or 19, because both apply. Can be used when you have a provision like this, which could be utilized by the state. Because otherwise, they could become vulnerable to challenges under 14 and 19. Those are provisions, for example, which we could defend on that anvil. Well,
Community first.
it's arguable. I think it will depend. I think it's arguable, but I'm very honestly, I'm not addressing your lordships on community and its scope. I don't want to take too much time on addressing that. I haven't gone into that in detail, but I feel it's best left on to a given date. Now, if your lordships can then just for 1 minute in the middle of this note, I'm done with this note. Middle of this note, Annexure 4, if your lordship sees, I have listed out the judgments. I
Forms, etc. This court struck.
if your lordship were to come to page 38, my lords. Page 38, just one para of Bhim Singh Ji, para 16A, 16 capital A. It gives a flavor of what could possibly go into this. About 10 lines down, your lordship sees the wide definition of industry. It's underlined, the underlined portion. Page 38. Bottom, it's underlined in red. Let's have it. It says, Mrs. Misra?
Begins with certain basic facts. I mean, the paragraph begins with that.
Yes, just about 8 lines down, you
Yes,
find the
that's
part
the
with underlined.
highlighted
Yes.
part.
The wide definition of industry or the use of general words like any person and any purpose cannot free the whole clause from the inarticulate major premise that only a public purpose to subserve the common good and filling the bill of Article 39B and C will be permissible. Even a private industry may be for a national need and may serve common good. Even a medical clinic, legal aid bureau, engineering consultant's office, private ambulance garage, pharmacist shop, or even a funeral home may be a public utility. Professions for the people, trade at the service of the community, and industry in the strategic sector of the nation's development may well be in private hands in the transitional stage of our pluralist economy undergoing a Fabian transformation. Why should lands allotted to such private industries or professionals be condemned? The touchstone is public purpose, community good, and like criteria. If the power is used for favoring a private industrialist or for nepotistic reasons, the oblique act will meet with its judicial Waterloo. To presume as probable graft, nepotism, patronage, political clout, friendly pressure, or corrupt purpose is impermissible. the law will be good, the power will be impeccable, but if the particular act of allotment is malafide or beyond the statutory and constitutional parameters, such exercise will be a casualty in court and will be struck down. I endorse broadly everything that is included here. Now, this is not a dissent. This is been endorsed as part of the majority itself. Now, if I can trouble your lordship, I'm done with this note. If you can just come to note 2M. M. The first point is that there is no revival. Do all my lords have 2M?
Yes.
Justice Masih has it?
Yes.
Yes. 2M, the first is that the word revival is a misnomer because there has been no death at all. Your lordships can skip the first 3 bullet points. The fourth one refers to Annexure 5, where there's a list of cases dealing with what the effect of void is. I'm not reading it, your lordship may see it, but the void, effect of void, which is common to 13.2, which is common to 368, and which is common in this kind of circumstance with a basic structure violation, is that everything is effaced all the way to the beginning. It's, as Mr. Salve put yesterday, entirely stillborn. If my lord will see the last bullet point, which is interpreting Article 368, as per 368.2, the effect of a valid amendment is, this is from 368.2, that the Constitution shall stand amended in accordance with the terms of the bill.
That's
so if it is struck down, it means it shall not stand amended, which means there's no amendment at all. That's the effect of it being void. Because it uses the word shall stand amended. Therefore, it shall not stand amended now if the amendment is not there.
Yes, we got that.
Next one is that it applies to the Constitution. The primary point is the onus is entirely on the petitioners when they say that the doctrine of revival does not apply to constitutional amendments. The doctrine of revival applies to statutes. There's no doubt about that. There's a whole series of judgments. I put it on at Annexure 6. A whole series.
Statutes also, there is a principle that a repeal of a repealing statute
Yes, that's a general
does not
clause.
revive the original
Correct.
statute, subject to any intent to the contrary.
Correct. Now that's been fully dealt with in NJSC, so I'm not going to go through that all over again. Here, the question is, you have taken one principle out of dozens of principles that we apply day in and day out in courts in this country. Whether it's res judicata, whether it's special versus general, later versus earlier, etc. All those provisions apply whenever your lordships are interpreting statutes of any sort. Suddenly, a barrier has been put up, as far as we are concerned, and told, sorry, that all that applies to legislative enactments. For some reason, it doesn't apply to constitutions. Why it doesn't apply to a constitutional interpretation is for them to discharge, which from that day in 1997, when they sought this reference till today, they haven't discharged this onus. They've raised the question and left it hanging as to why, when you have in constitution bench after constitution bench, this court has applied this principle, why suddenly when it comes to the constitution itself, you will say no. There is suddenly an onus on us to show how it applies, when in fact every other principle we have applied.
They have touched upon this pen and ink theory, which they have not elaborated.
Correct. So I substitute that phrase, I'll address it right now. I'll substitute that with pen and eraser, and I'll explain why. When there is a substitution of a provision, whether it's in a statute or whether it's in the constitution, when there is a substitution, it starts with erasing. So you rub out the words 39B and C, and then with your pencil, you put in part 4, all the provisions of part 4. Now, there are two aspects. This is linked to what Mr. Dwivedi addressed, your lordship. There are two aspects then. You have first done a deletion and then you've done an insertion. Now, when both are struck down, your penciling is reversed and your erasing is reversed. So you're back to square one, you're back to what was there at the inception. So this principle of pen and ink has evolved both here and abroad in the context of provisions of law. No distinction has been made saying, oh, in a constitution, suddenly we will not apply a perfectly logical principle. There is absolutely no reason why it should not apply the constitution. So the onus is on them, which they have not discharged. The second is and this has been pointed by our side many times, that the question that was referred was only from 3 to 5 judges. This doctrine of revival. It was never renewed from 5 to 7 or 7 to 9. It was only at that stage from 3 to 5. And that has been answered by this court in 5 judges in NJSC. So if it's been answered, the question, that very question, whether doctrine of revival will apply to constitutional provisions, has been answered. If it's been answered, then A, it doesn't survive for answering now. B, it's anyway been answered, and it's not so perverse that it needs to be disturbed.
Mr. Shankaran, I think
I'm wrapping up. That's why I'm going much quicker than I would. I'm skipping a whole bunch of points, Manoj. This is just a 3.5-page note, and I'm almost done. On 31C, there are 8 Constitution Bench judgments. 8. I've listed 6 here. There are 2 more which deal with electricity, Thane Electric and Tinsukia. All these, this is point 7 at page 3 of this very note. These 8 judgments all deal with this provision specifically. All of them deal with 31C and treat 31C as existing in the form in which we argue it exists today. But most importantly, COILO, which is 9 judges, which is important because it's a unanimous 9-judge judgment, employs the word at para 52 of COILO. I'll just read that sentence out. In Minerva Mills, while striking down the enlargement of 31C. This is a coordinate bench's understanding of what 31C did, that it enlarged from just 39B and C to the entirety of Part 4. This is the sentence at para 52 of Chief Justice Agarwal's judgment. So the enlargement and the fact that 31C in that state stayed rooted after the Minerva Mills decision, without a doubt, from 8 constitution benches, including a 9-judge one.
What is that sentence read like?
In Minerva Mills, while striking down the enlargement of Article 31C through 42nd Amendment, which had replaced the words of or any of the principles laid on Part 4 with the principles specified in Clause B or Clause C and Article 39, Chandrachud's GA said, and they've referred to Section 4 of the Act, and then they've gone on to para 53. But the understanding was that was an enlargement. What the effect of it was only a mere enlargement. So you open the door a wider crack. That door has been shut by Minerva, and that's the understanding and how 31C has survived throughout. Now, therefore, a long, consistent understanding constitutes stare decisis.
Yes.
One large, substantial point now at the end, which, if your lordships will see, absurd consequences have already been dealt with. In fact, it will surprise your lordships to know, perhaps you know it already, that this 42nd Amendment, to the extent that those words socialist and secular were inserted, has been challenged before this court by Mr. Ashwini Upadhyay. Yes. And it's pending. It was listed on Monday. Now, if he were to, by some strange means, succeed, then the entirety of that would disappear from the preamble, because what they did was not insert 2 words, they substituted the entirety of it. There are many other examples.
To Mr. Upadhyay's creativity.
We will, but I'm just giving. So annexures 9 and 10 give an illustration of all the provisions in the Constitution where there has been either omissions or there have been substitutions, and the effect of that, particularly annexure 10, your lordships may see. And now, my lords, Roman law, annexure 11, I have mentioned the roots of that and what I believe. I put a chart to show what could be covered. The last point is an important point, and this is, when any of these matters come up for decision making by a smaller bench, which is their suggestion, that apart from these other questions, they'll take everything else. The important aspect is going to be about Article 14, 19 and the reliefs that can be granted by courts. Today, unfortunately, because of this recent development, we have a situation where on Article 14, there seems to be a divergence of opinion in this court on the reliefs that can be molded when there has been a finding of a violation of a fundamental right. The recent judgment in Suprio, which is that same-sex marriage case, the majority there has come to the conclusion, all 5 judges agree that the situation is discriminatory. They say there is a violation of Article 14. However, the majority says that while this court finds that there is a discrimination, there's not really anything we can do about it. And we leave it to the state to attend to it through a legislative mechanism. The minority takes a different view and says that the Constitutional Court has evolved over years till a stage now, where once the court has found that there is a discrimination, that has occurred as far as the citizen is concerned, it is an obligation of the court to ensure that a relief is molded and provided. Maybe in the interregnum, maybe permanent, whatever it is, a relief has to be granted. The majority view is there is no incumbent need to provide such a remedy. Now that judgment, the majority judgment, is very clearly per incurium, because there are 3 constitution bench judgments which have not been considered by. No, I didn't even appear in that case. And Mr. Solicitor, please take your seat. You can't interrupt like this. I'm not on anybody's side. I'm assisting a constitutional court. Now, it is necessary for the purposes of the Constitution and its interpretation. Yes. Mr. Mehta has heckler's veto in this court, clearly. Whenever he's done, my lords, if I can continue my address. Now,
Yes.
it is necessary for this court to settle the position.
All right, we got the point.
Now, no, I'll
You
just
have to
explain.
specify.
I've mentioned in the note the 3 constitution bench judgments, one of which was cited in the SEC online version of this judgment. All the arguments placed by the various counsels are also provided, which shows that Mr. Ramachandran specifically referred to one of these judgments, yet the majority doesn't even refer to it. It is squarely on the point, the fact about relief molding when Article 14 violations take place. Now, if I may say, a 5 judges bench cannot take that call of another 5 judges bench being per incurium. So that will compulsorily eventually have to go to a 7 judges bench to decide. I would suggest that your lordships may declare the law one way or the other. Just consider this, it's very critical. Because everybody, all citizens need to know that if I have a violation of a fundamental right and I come to this court, is the court going to follow? There isn't. But since it's a pure question of law,
will take it up in.
your lordships have that. Your lordships have the authority to take up any question of law.
Many counsels on that, not your argument.
No, that's fine. Your lordships can take it up. I'm leaving it entirely. I have to make the argument because I think there's an obligation to make the argument. That may be. I'm assisting on my own. Yes, I'm assisting on my own. This is my submission on my own, which I'm entitled to. I don't need anybody's permission to make a constitutional submission.
Lord,
I don't need anybody's permission to make submissions in this court. I'm grateful.
Lord, this is neither central submission, this is not State of Maharashtra submission.
It's not.
And Mr. Dwivedi said it's not submission by the State of West Bengal.
It's not only-
really unfair that we have to give rejoinder to somebody who is supposed to be, Lord, arguing the same point, Lord, which we are arguing. I'm saying this respectfully. I won't be able to
I don't
be
have-
rude or, Lord, rustic, that's all.
I'm not even remotely claiming it's anybody's instructions. As a lawyer assisting a constitutional court, I don't need instructions on a pure question of law.
The court has not appointed you, amicus.
That's okay, I'm not. I'm grateful, Manoj. I'm most.
All right. Yes, Mr. Diwan.
Yeah.
Mr. Diwan, leave some time for the rejoinder.
Well, Mr. Andhyarujina assured me at the lunch break that he'd used his persuasive powers to urge you to sit beyond 4 p.m. As you have.
I don't
In
know
the
about
past.
that, but Lord, I have used
I
my
will
persuasive
support
powers
that
on my solicitor to
request.
delay my flight. But I don't know if I can persuade your lordships to go 15 minutes later for tea perhaps. So that's about it.
All right, then I'll go as swiftly as I can. I'll just mention the points. So first, Manoj, I am appearing for the JVPD Tenants and Residents Association. I am respondent number 3 in writ petition number 660 of 1998. JVPD Tenants and Residents Association. Second,
have not made any submission.
He's basically arguing a question of law.
I
the
thought I should
constitutional law.
identify my.
Nothing
who
on
I
the
am.
facts, nothing on the facts, on who these tenants are. We have the learned senior counsel giving us some new ideas or inputs, that's all, nothing more than that.
My written submissions are in volume 2O. I will supplement those with submissions that with an additional note. But let me just indicate to you that I will make points because time is short, and I'll make those points under 5 broad heads. And if your lordship feels that one is straying, your lordships will indicate that I should sort of curb it. Let me just preface this by making 2 statements. The first is that your lordships in a constitution bench in KK Kochini my points. So before I give you those clusters of under 5 clusters of points, there's just 1 or 2 prefatory remarks I want to make. So, your lordships, on the 4th of March 1959, in a constitution bench of 5 learned judges in KK Kochuni's case, which is at volume 5H, and the relevant paragraph of that judgment is para 11. I'll just state it. Said that this court.
What page?
Well, it's just in this volume. There's just 1 page, one. So it's volume. If your lordship likes, I can give you the citation.
No, that's fine. Kochuni.
Yes, KK Kochuni. It's 59 sub 2 SCR 316. But in the version which we have given you from SCC online, there are paragraph numbers. The relevant paragraph number is para 11. And this is for the proposition because a contest was there as to whether this court could issue declaratory relief.
All the learned counsel, please start citing now the digital SCR, because I can't
Digital
tell you
SCR.
how much our team has worked on it, and we have brought it up. It's the official report,
We'll put
absolutely
it
up to date.
Yeah.
And please do cite our official law report now.
We'll do.
With the neutral citations, we also have neutral citations.
Very well. We'll do that. So, Manoj, the contest.
It's like a book. It's not even like a PDF in a PDF form. ESCR was in a PDF form. DGSCR, in fact, you can just, while sitting here, just surf it on your iPad. It's in the book form. You just flip a page as you flip a book's page. Yes.
So, Manoj, Kochini was on the case because at that point of time, there was a contest and a preliminary objection raised as to whether this court under 32 could issue declaratory relief. And the contest was, were you required to file a suit under the Specific Relief Act? And the court said that no, we can issue declaratory reliefs. The only reason I'm mentioning this is, it's very important with regard to the nature of the declaratory reliefs, which your lordships have seen, granted in Minerva Mills. And here I'm just pointing out one para 75 has been placed repeatedly before your lordship.
So what is the principle from Kochuni that you are extrapolating, Mr. Diwan?
No, the only, this is just prefatory. Declaratory relief can be granted by this court to declare. Here, thereafter, I point to paragraph 75 of Minerva Mills, and please see the nature of the declaration. The language is absolutely clear. And insofar as section 4 of the 42nd Amendment is concerned, that is set out in Mr. Dwivedi's note in the Solicitor General's note, but you will find it at page 3966 of volume 4.
We saw that. Yeah.
Your lordships have seen that. Now, Manoj, I want to just mention a dimension which is under judicial review. So I'll just state the points under judicial review. If the submission of the appellants or the petitioners here is accepted, then in our respectful submission, it will severely impact the power of judicial review of this court. And that ought not to be allowed. Now, let me indicate how. First, judicial review has been accepted right from Keshavananda Bharti as an entrenched provision, an entrenched feature, and therefore it's part of our basic structure. Keshavananda, your lordships will find there are observations in Minerva Mills, in L. Chandrakumar, all to that effect. I'll give you the paragraph numbers, but this is very, very well established. Now, how does this cripple and undermine judicial review is the point which I am seeking to press. The theory being put forth is that on a correct understanding, when your lordships issues a declaration or issues or strikes down a particular provision seeking to amend the constitution, there remains a hole in the constitution. So it's some sort of a Swiss cheese full of holes that will result, and you will have a constitution with hole after hole after hole. Now that cannot be and ought not to be a policy or a manner of interpretation that ought to be encouraged. An interpretation should be encouraged where the court is focusing on what is the provision, how is it infringing a part of the basic structure, how is it violating certain essential fundamental rights or other features of the constitution, not that the court should be focused on, oh, what will happen after I strike it down? Because there will be X hole or Y hole, and you will have a number of holes. So that's my first point. The second point I wish to make is that as far as judicial review is concerned under our constitutional scheme, it is not codependent on any other limb or branch of government. It's a power entirely vested in our constitutional courts. The theory being suggested by the other side is, and it develops and requires a codependence between not just the court, but also the court and the legislature to fill a gap. So I would respectfully submit that is contrary to separation of powers. It's contrary to the notion of judicial review, which is vested entirely and only in this particular institution. Do not please accept a set of submissions which will result in a situation where, despite your lordship's judgment and final declaration, there will still be something else required by somebody else for the purposes of a meaningful way forward. That's the second point. The third point I wish to make, which also touches on judicial review, is, so the third facet is really the efficacy of the judicial process. This severely undermines the efficacy of the judicial process if you are going to have a system or a suggestion or a theory which is accepted, which requires another branch to also give complete effect to what this court seeks to do in protecting rights of citizens. Now, please look at this examine this issue from another perspective, again from the judicial review angle. I would respectfully submit that please put your lordships in the please put yourselves in the shoes of Parliament. In my respectful submission, had Parliament known that these particular provisions were indeed unconstitutional and stillborn, they would not have enacted the provision at all. It would never have been the intent under Article 368 to remove Article 39B and C. So they would, had they the knowledge or the understanding, when they brought about this particular constitutional change through Section 4, they thought, as your lordships correctly put it, they were expanding the scope. But had they known that this is something which will not pass constitutional muster, they wouldn't have done it at all. So therefore, the position we are canvassing, which is to say that the provision prior to Section 4, which has been now held to be unconstitutional and void, must obtain. Otherwise, of course, there are other submissions also with regard to the fact that there is that it will result in absurdity. But I am just placing this on another facet, which is judicial review. So that's my first set of points.
Oh, the first set of points, these four, right?
These are the points. Okay. Now I come to my second set of points. My second set of points is with reference to natural resource allocation case, the Constitution Bench judgment. Your Lordship will find that in volume 5D. And here, may I just place a few paragraphs. I'll just give you the paragraphs and then just place a few of them. According to us, the relevant paragraphs are 113, 118.
Volume and page.
Yes, certainly. My lords, it is in, it's in volume 5D.
D, page?
D. and it is at page 474. It's the printed page 474. PDF is, I think, 476. 474. Then the discussion, yes, it's serial number 14 of the index. And the discussion on Article 39 begins at paragraph 113. Now, this was, as your lordship knows, in the context as to whether...
130.
Yes, 113. Milords, I'm giving you the paragraph numbers.
Yes.
The relevant paras are 113, 118, 119, and 120.
Yes.
Now, if you permit, I can take you to PDF page 558 and just place it, or I'll summarize it
Just
for you.
summarize it.
I'll summarize the point for you, Lord. What this court has held essentially is that, look, as far as articles of, I mean, the Constitution is intended to endure, and so are these provisions, particularly the directive principles of state policy, because they are to guide the legislature and all branches of government moving forward for as long as the Constitution endures. Now, in a situation such as this, the Constitution bench in natural resources, in the paragraphs which I have indicated, thought there was great wisdom in giving a wide interpretation to each of the expressions which was used within Article 39, and to leave it to the wisdom of governments, and in fact they use that expression as well, of the future, to interpret, to create, to define. So I am relying upon this Constitution bench judgment essentially to advance the proposition that there may be great advantage in a situation where we do not confine the scope of these particular articles and sub-articles and leave it to the future for governments to recognize their contents depending on the exigencies of that age. So that's, my lords. Yes. So therefore, my lords, what the court emphasizes is that these are matters of policy which the government will eventually take a call on when the legislature steps in. So, my lord, that's my second set of submissions. The third, my lords, I'm going to request your lordships to just go to a few paragraphs of Mafatlal Industries. So now I'm on my third set of points. So Mafatlal Industries, your lordships will find, is in volume 5 at page 2797. And here, may I just request you directly.
They argued that Mafatlal Industries, the point was in issue, it was argued.
Yes.
It was contested, and
Yes.
even the concurring judgment refers to
Yes.
that.
So I completely support, my lords, those
How do you
submissions.
formulate your point on Mafatlal?
So, my lords, I want to just point out that in paragraph 76, which your lordship will find at volume 5, page 2865, the context in which this discussion takes place is mentioned. So there was a judgment of Kanhaiya Lal,
Yes.
which they eventually overruled for this relevant particular portion. And it's in that context. So if you permit, I can just show you a few relevant paragraphs from that.
You can just tell us.
All right. So then, my lords, I'll give you the paragraphs. So please note the paragraphs of this particular, of Mafatlal. So I am relying on para 76, particularly subclause 4, because there's a discussion on each subclause of para 76 separately.
In fact,
74
was also cited, yes.
So 74 was cited. And then your lordships will just see that as far as the remainder paragraphs are concerned, the ones which, sorry, your lordship will just give me a moment. Just a second. Two 2875. Yes, my lord, the discussion in Roman 4 begins at para 83 on page 2875, and the portions which the Solicitor General has also placed are paragraphs 84 right through till 86. So it was very much, my lords, an issue, and this is a 9-judge bench. We commend the same approach to the court. So, my lords, I am done as far as this set of points is concerned. Now, as far as MADA is, as far as the MADA Act is concerned, I want, with your permission, I want to just read one of the impugned judgments. So, your lordships have made it clear that that will probably go before an appropriate bench to discuss it. But I'd like to read, with your permission, four paragraphs from Justice Painse's judgment.
Into that.
All right, then I'll give your lordships those paragraphs. It will explain to you the perspective, my lords, because he's dealing with this particular act. And what is this common community of resources? What is the common good in the context of the Mahada Amendment Act? So I'll just give your lordships that judgment. The judgment your lordship will find is at volume 5, page 2655. It's at serial number 55. And the judge, sorry. It explains, my lords, it explains the context in which this whole statute arose. And I think this discussion, my lords, in the context of the peculiar circumstances which was confronting the legislature and the ground situation is set out and explained by the division bench of the Bombay High Court. May I just take your lordship to that? It's just volume 5. There are 5 paragraphs that I'll specifically point to. 2655, volume 5, serial number 55. Your lordships have it? The opening paragraph indicates the challenge to chapter 8A. Then please see, I'll just mention the paras I'm relying on. Paras 2, 5, 6, 13 and 14. 2, 5, 6, 13 and 14. Now just see para 2, for example. Before adverting to the challenge raised in the petition, it's necessary to refer to the legislative provisions which are relevant to appreciate the contentions raised in the petition. The land available for housing in the island city of Bombay is very limited due to the geographical limitations of Bombay city being the commercial capital of the country. The pressure on the limited availability of land is extremely heavy.
Sorry, 2655, right?
Yes, 2655. The prices of houses were always on the rise, and it is extremely difficult for persons belonging to the lower income group or even the middle income group to secure shelter by payment of a reasonable rent. The legislature realized the plight of the people residing in the city as far back as 1938. The Bombay Rent Restrictions Act 1939 was not in excess of rupees 80 per month. After Second World War, the rents skyrocketed and it was impossible for the common citizen to secure housing accommodation in the city. The break of war resulted into shortages of building material, and the government was required to step in and issue orders under the provision of the Defence of India Rules 1939. In the interest of the legislature thereupon enacted the Bombay Rents Act 1947 to replace the earlier acts. The Bombay Rent Act covers the towns of so-and-so. The Vidarbha region is governed by the Rent Control Act and is known as the Central Provinces and Berar Letting Act. Then please go, the dominant intention of the legislature in enacting the Bombay Rent Act was to uphold protection to the tenants from wrongful eviction and also to ensure that the tenants are able to secure housing accommodation at a reasonable rent. With the object in view, the Rent Act provided that the landlord shall not charge rent in excess of the standard rent, and the expression standard rent means that the rent that was payable for the premises on September 1st, 1940. In other words, the legislature had frozen the rent which the landlords were recovering on September 1st, 1940, and has issued a fiat not to recover rent in excess of the standard rent. Then please go on, if your lordships would, to paragraph 5. On February 26, 1986, the governor of Maharashtra issued an ordinance, being Ordinance 1 of 1986, to amend the Mahada. The ordinance was converted into amending Act number so-and-so. The statement of objects and reasons of the enactment of the amendment sets out that there are
my learned brother says that you have given the gist of Justice Painse's judgment in 2O page 60. So
yes, it is. So your lordships will see examine that. But essentially, my lords, what the judge says in the remaining paragraphs, which I was planning to read, was basically that, look, there is this huge stock of housing. There are these tenants which are affected. This is a community resource, citing the preamble to the enactment, etc., and explains as to how and the context in which these statutes came to be passed. So that was really the purpose in which, so it takes various different dimensions is the point which I wanted to make, and we have summarized this in our list of dates. Finally, Manoj, I might just mention this to you. So Manoj, this is essentially, I wanted to just contextualize the act. I believe the division bench has, we are not deciding on the correctness of the judgment here in this combination, but it sets out the logic of the legislature and eventually upholds the amending statute, which is, of course, subject to challenge before this court. Manoj, my final set of points are really with reference to the written submissions which we have made. And here may I just mention 3 paragraphs or 4 paragraphs to your lordships. 35N, I've indicated to you as to where my written submissions are placed. It's in volume 2O, and I'll just highlight without reading them 3 or 4 paragraphs. So there is 35 subpara N at page 25, paragraph 39 at page 27, 40 to 41 at page 31 of volume 2O. Now let me summarize as to what we have included in these 4 or 5 paragraphs that I'm just mentioning. One set of submissions that we have made are with regard to this notion of premium or pagdi, and on the basis of the material which was available and culling out from the material which was also before the legislature and which was put in the statement of objection and reasons. So, for example, Manoj, there is a reference in our written submissions that the committee, Manoj, ahead of the 1999 Rent Act, estimated that between 1947 and 1997, more than 70,000 crores was paid as premium or pagdi. So the legislature is aware of these premiums. Of course, the 99 Act, as your lordship knows, legalized pagdi. Prior to that, it was not legalized. So these are some of the features, because there was an emphasis, and I don't blame them, saying that, look, these rents have frozen in some certain situations, it is most unfair. So all I'm pointing out in these 3 sets of paragraphs is that the legislature has counterbalanced as far as the interests of landlords, etc., are concerned, by legitimizing and legalizing pagdi, though pagdi was, as a matter of practice, going on even under the old regime, number 1. Number 2, it has permitted certain sets of transfers to be allowed in terms of premium. A second part of the package was that certain types of companies with turnovers, multinationals, etc., were brought outside of the remit of the Rent Act. A third was that there was an escalation which was mandated by the Maharashtra Rent Act. So that will again be looked at by the appropriate bench. But there were a package of measures which your lordships have noticed. And I thought we should just mention this. There are references in the written submissions we have filed to in our footnotes to various affidavits, should that necessity arise. So this is my respectful submission. I'm very grateful.
Yes, Mr. Yes, Mr.
Mr. Andyarujina would be arguing for.
We have to give now everybody 45 minutes. So maybe if once Mr. Andyarujina finishes, if we have a little time, we'll give you a hearing. Yes, Mr.
I just wanted to point out the volume numbers.
Give us a small 1-page note. Yes.
Only 2 small points, and then I'll.
Yes.
The claimant, the petitioner appellant side has filed written submissions from A to I. H and I are written rejoinder submissions. H is filed by Mr. Andyarujina, I by me. And the respondents have filed volume 2, A to U, 21 volumes are the rejoinder submissions.
Yes, Mr.
I find, my lord, that I have circulated a rejoinder note, which, my lord, by some small miracle, more or less covers everything that my colleagues have said today as well. But may I request your lordships to see that?
Where is that?
But it is called 1H. Lord, and given the fact that, Lord, we are constrained for time, Lord, my approach is to show your lordship the material from which I put into the note.
1H hai kya hamare paas?
But it looks like this.
It's been emailed and put on the Google Drive. The link. We've emailed it also about
Upload
half an hour back.
He just upload.
Till it comes to your lordship, Lord.
Just take 1 minute.
Sure,
Just wait
please.
for a second.
Lordships and I have a common objective. the lordships to bring this to an orderly close, but need to reach the airport in time. So but hopefully we'll both get there.
There, you know, the pull of Delhi is infectious.
I have noticed that. But there are certain sort of gravitational forces in Bombay as well, as your lordship knows, but it is. Especially if your lordship is.
Have gone into
All or any of the
cheese holes. And the arguments, I think Mr. Shamjivan brought his arguments from the kitchen cellar. So,
No, your lordship was very euphemistic. But your lordship didn't say the junk mail folder.
No, no.
Obliged for that.
Yes.
So hopefully we'll find it. Extract it.
yeah,
So rejoin. Thank you.
I was acting as a mouse, you know. On cheese.
It's a deadly combination. No? The mouse and the blue cheese, as they say.
Only virtually. Only
Sister.
virtually.
I've gone vegan, so cheese is out of question. Yes.
But if I can just step back from the note for 1 minute, because a lot of material has been used before a lot of submissions have been made. But my attempt in the rejoinder is to, in one sense, give some order to this material. I'm not the first point I want to make to your lordships. I believe that this is a not significant point given the time spent by my lordships. But it is a conceptual error to conflate the idea of voidness, whether it is voidness ab initio or otherwise, with the doctrine of revival. I'm not going to tell you, Lordship, why I say this. But and I was fully conscious of this when I made my own, and therefore I didn't elaborate on the aspect of voidness. Voidness is something that goes with the declaration of unconstitutionality, so Lordships make it. But it is a doctrine which deals with the effect of Lordships declarately order the statute. It makes no difference in my respectful submission whether it is sure. But the cases are settled on this aspect. The effect is to rob it of all legal effect. It becomes legally destitute. Now, my learned friends, for arguments, proceed on the basis that because it is void, we must treat it as factually non-existent in the statute book. But in my respectful submission, that is to conflate two different concepts. I tell you what you find. But I understand this requires a little bit of explanation. Bear with me a minute. But I don't think there is any dispute about the fact that your Lordship's declaration, and I'll deal with the different types of voidness because I noted carefully what my Lord the Chief Justice put to me the other day. Lord, renders the decision void at some level. You may say void on the date of the declaration. You may say void on the date of insertion. You may say void on the date of amendment. But all of those are statements which go to the legal effect of the remaining language. That, in my respectful submission, is not really the point that we are grappling with. The real point that we are grappling with is a question which is apart from this. It is the question of whether the old provision can be resurrected or come alive again. Now, my learned friends in their argument, and I notice
Their argument is that the old provision never died
yes,
in natural
it
death.
is always latent and it is always there.
Because because the process by which the new provision was sought to be inserted in substitution of the old provision, that itself was stillborn. So in that sense, it was not the substituted provision which ceases to be of effect, but the substituting provision ceases to be of effect.
I fully appreciate that point, Lord. And my response to that point, Lord, is twofold. But one is what I've already said, the pen and ink theory. But we may regard that as some sort of abstruse doctrine of constitutional law. So, Lord, I actually have a better answer for you. Lord, and the answer is this. Lord, that when we declare something to be void, we rob it of legal effect. Lord, it is something that courts do day in and day out. But the voidness doesn't carry with it the consequential actions which may follow as a result of the voidness. But in this case, the legislative cleanup or the legislative sweep up or the legislative reenactment. Now, when your Lordship puts it to me to say that, as my learned friend Mr. Shankar Narayan put it, that in fact it's never dead. Lord, I respectfully disagree, but I see a situation where that could be the case. Lord, where under Article 368(2), the procedure for bringing about a constitutional amendment has not been followed. The law has never taken effect as prescribed by 368(2). It is entirely possible to say that the old law has not been dislodged and the new law has not become alive. So, Lord,
but if the basic structure is a limitation on the amending power itself, in which case compliance or consistency with the basic structure is a condition precedent to a valid exercise of the amending power.
I see that point.
And then if the condition precedent is not fulfilled, then the process of substitution itself never took effect.
So let me immediately try to answer that point.
And that's why the declaration that Section 4 was void was all that was necessary. They didn't have to go all the way to say that 31C is void. Because if the substitution had taken effect, they would have had to declare 31C as void, which they never did. They said that Section 4 is void for the reason that the substitution was never carried out as a matter of constitutional doctrine. That seems to be the line of argument.
So, but let me try to answer your Lordship, Lord, with 3 or 4 points. But the first is this, Lord. There are various types of voidness. Lord, voidness for lack of legislative competence. Voidness for
breach of fundamental rights
under Part 2.
Any other constitutional limitation, and basic structure.
And basic structure. Now, Lord, basic structure, Lord, has actually received its own nomenclature, as your Lordship has noticed from Minerva. And the correct nomenclature, but we don't need a new nomenclature for that, is beyond the amending power of the Constitution. That is the language which is consistently used when it comes to basic structure. So, Lord, we are in a situation, although a judge-made situation, of akin to legislative incompetence. Akin to it. We are in a situation where it is a limitation on the constituent power Therefore, my learned friend, Mr. Dwivedi, used language with regard to the using constituent. But it has already been dealt with by our courts. And what they say is that it is
Now,
beyond.
because the basic structure doctrine is a limitation on the amending power.
Yes.
And something which is done in violation of the basic structures beyond the amending power.
Madam.
That means that exercise itself has no constitutional.
So, Manoj, does it mean that is what I just want to
It
explain?
has no constitutional foundation. It's not that you have enacted a valid law, inserted it into the statute book, and then law happens to violate part 3 of the Constitution.
Madam.
Here, it's a situation where you've acted on an area where you had no power whatsoever. You were beyond your amending power.
I follow.
In which case, it doesn't enter the process of an effective constitutional amendment. It doesn't enter the constitutional fabric of 31C. It remained at a stage anterior thereto, namely an exercise by the Parliament, purportedly in the exercise of its power under 368(1).
I follow what the Lordship says. But my response to your Lordship, my respectful response to your Lordship, Lord, on this point is this. Lord, the lack of constituent competence, Lord, which is the basic structure point, Lord, is very akin to the situation where there is a lack of legislative competence. It is almost identical. Lord, and therefore, Lord, I thought a great deal about this. Lord, there are many cases which deal with lack of legislative competence in the context of normal statutes. But in
There's one critical difference,
Yes,
where there's a lack of legislative competence, the power to enact the law vests somewhere in the system.
Yes.
See,
I follow what
because
Lordship says.
in the case of a breach of the basic structure, that power does not exist in any organ of the state.
Lord, I accept what your Lordship says there also. Lord, so the basic structure doctrine is an implied limitation. It is an implied limitation which prevented that particular amendment from being passed. Lord, I accept everything that your Lordship said. The effect, therefore, of your Lordship's declaration of unconstitutionality, let us take it at its strongest, declares it void ab initio, as if it never existed. But, my Lord, my point to your Lordships is this. The statement of voidness is a statement limited to legal effect. Now, Lord, allow me just to elaborate this. Lord, what happened, Lord, with regard to this particular amendment? And Lord, and I just want to draw a distinction where I believe that your doctrine, Lord, holds, where what your Lordship put to me holds true. But if your Lordship takes up my note for a minute, Lord, I have set this out to just prevent us from having to go elsewhere for it. But please come to paragraph 16 at page 111. Now, my Lord, my point to your Lordship is this. And here I want to deal with one of the points raised by my learned friend, Mr. Dwivedi. But paragraph 16, if your Lordships have it, at 111. But perhaps at paragraph 15, your Lordship will get a broader idea of what I'm saying there. But the point, another way of looking at the point, is the point which was also made by some of my learned friends, Lord Mr. Salve, Mr. Dwivedi, Mr. Shankar Narayan, to say that view section 4 in isolation. Don't view it as becoming a part of 31C. So what I'm trying to deal with that point. Your Lordships have it. Paragraph 16.
At page?
What is that? Page 111. 111.
Notice only page 22. PDF page 6. In the note, right?
PDF 6, I believe. Your Lordship is right.
16. Since section 4 begins as section 4 had.
Not it becomes section 4. But I just refer your Lordship to the paragraph before that if your Lordship doesn't mind. What, para 15? Para 15. All of your Lordships. The argument that the order and judgment in Minerva Mills merely struck down section 4 to be unconstitutional and not, it should say Article 31C as amended by section 4 is stated to be rejected. Section 4 had, in accordance with subclause 2 of Article 368, resulted in Article 31C standing amended in accordance with the terms of the bill on 18th December 76. So not first is the factual position. From this day onwards, Section 4 was a part of Article 31C, and Article 31C stood so amended. Any declaration of unconstitutionality with regard to Section 4 after 3rd January 77 is necessarily to be read as a statement of unconstitutionality with regard to Article 31C as amended by Section 4. Now, look, to this point, please have a look at the order passed in Minerva Mills. Not I've extracted it, but if your lordships will kindly go.
No, but the logic you are trying to make read other. There are 17 and 18.
Yes, sir.
Then it makes sense what you are saying.
Yes, sir, I will. So,
That they have already answered. You read para 70 so that
yes,
it becomes
17, please, Lord. From this day onwards, Section 4 was a part of Article 31C, and Article 31C stood so amended.
Now 18.
18. Any declaration of unconstitutionality with regard to Section 4 after 3rd January 77 is necessarily to be read as a statement of unconstitutionality with regard to Article 31C as amended by Section 4. In fact, it is evident from a reading of the order in Minerva Mills that the Honorable Supreme Court also regarded it to be so.
In other words, 31C is not there.
But that part of 31C is no
But
longer.
no,
Then what
what you are
remains?
saying is 31C is not there. No part, no this. You are saying 31C is not there. This is what you mean, isn't it?
What I mean to say is actually the amended part of 31C is not there. But that's what I mean to say. But therefore, Lord, I regard this, that's why I call my note the dead letter. There is nothing meaningful left in 31C. That is the point that I seek to make to your lordships. Lord, I see the fact that this is a conceptually difficult idea. Just bear with me a few minutes. Just have a look, Lord, at the order in Minerva Mills. Lord, what did the learned judges think they were doing? Lord, it's quite clear from their own statement. But please have a look, Lord, I've extracted at paragraph 10. I know we've read it several times, Lord. Just I'll be very brief with it. Paragraph 10.
Of your notes?
Yes, please. Of mine. I put everything into my note. Hopefully, I won't need to take your lordships elsewhere. What's PDF 4? PDF 4. But if all your lordships have this one. The Honorable Supreme Court, by its order of 8th May in Minerva Mills, passed inter alia the following order as far as 31C is concerned. Section 4 of the Constitution Act, which came into force with effect from 3rd January. Now, please note the language of the court. Amended Article 31C of the Constitution by substituting the words and figures, all or any of the principles laid down in Part 4 for the words and figures, the principles specified in Clause 6 and Clause C of Article 39, Article 30. Sorry, it should say Clause B, I'm so sorry. Article 31C as amended reads as under. Now we have the new article. Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of Parliament and is void since it damages the basic and essential features of the Constitution and destroys its basic structure by a total exclusion of challenge to any law on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 and 19 of the Constitution. If the law is for giving effect to the policy of state towards securing all or any of the principles laid down in Part 4 of the Constitution. Now, Lord, I don't want to make too much of this, but my Lord, the point that I do want to emphasize to your lordships is that, my Lord, every precept of constitutional law tells us that once the procedure under 368 stands completed, we have a new amended article. And my Lord, in my respectful submission, my Lord, the doctrine of voidness is not effective against that. Now, the doctrine of voidness, as your lordships have rightly noted, is a tool at the hands of your lordship for a variety of purposes. Void from the date of the declaration, prospectively void, retrospectively void, void ab initio. But, my Lord, to my earlier point, my Lord, this is a question of constituent power. My Lord, this doctrine of voidness does not bleed into constituent power. My Lord, if any separation is to be maintained, my Lord, it is with regard to constituent power. I can understand, and what my learned friend Mr. Dwivedi said, I understand its spirit, but I would put it differently. Under 141, your lordship declares the law. But I fully understand that. Keshav Nanda Bharti itself, not judge-made law. The implied limitations, judge-developed limitations. But, my lord, at the same time, it is for your lordships to strike that balance. Constituent power, the power, and that's why, my lord, I take a little bit of difference with my learned friends when they seem to suggest that the doctrine of revival must be equated with an ordinary statute. But it may, in some cases, be the same in the case of substitution. But this is a power of a high order. Lord, it is given only to Parliament. There is a special procedure which is to be followed. And in my respectful submission, this doctrine A fortiori all the more applies to the exercise of constitutional substitution. Now, Lord, Lord, if there's any point I wanted to make in the rejoinder, I did want to say that the question of voidness does not affect the separation of powers and the constituent power of Parliament, which continues to reside only with Parliament. Now, Lord, it's often said, but this is a highly technical point you're raising, but it should be swept up. My Lord raised a everyday problem. How do we know what is the law? Lord, if your Lordship's court is to work in perfect tandem with Parliament, Parliament should immediately step in and re-legislate in some way. Lord, it doesn't result in a void. It is resulting in a void because your Lordship's court has done its job, but Parliament has not, in my respectful submission. But there's nothing odd about it. There's nothing strange about it. In fact, my Lord, if we understand this way, it is in perfect harmony. The courts work with Parliament. You strike it down, Parliament may reenact. But in the circumstances which we know. So, Lord, in my respectful submission, it would be a conceptual error to conflate voidness with constituent power. That's
This was answered.
I'm so
This
sorry.
was answered by Mr. Diwan.
Yes.
Who said that, this is curtailing the powers of judicial review.
Yes. I just want to deal with that.
Because if we depend upon whatever we decide as a judicial review, we depend upon the Parliament to rectify it, then where's the power?
Let me answer that immediately. Lord, as Lord has been said, Lord, by celebrated jurists, Lord, 32 is the soul of the chapter on fundamental rights. Fully accept that. But Lord, I ask myself, your Lordships, a question. Judicial review is always a limited doctrine. When your Lordships judicially review administrative action, your Lordship will set aside the decision, but can never take the decision for the decision maker. And that is the point of the balance. Your Lordship's power is plenary insofar as it resides in your Lordships. But there are limits. The decision must be taken by the decision maker. Parliament must exercise its constituent power. Lord, I, for one, with great respect, find it to be perfectly harmonious. In fact, I find the other interpretation of voidness to be something that requires a legal exercise and is not in consonance with the separation of powers. But I hope I've answered your Lordship's question. Judicial review is a doctrine of a limited nature, by its very nature, my Lord. But when your Lordships judicially review executive action, your Lordships set it aside, quash it.
Are with the Parliament 360 ordinary powers.
My Lord.
They are limited by basic structure doctrine.
My Lord.
Now, if it encroaches upon that, then it has to be declared as unconstitutional.
It does.
And then, after it being declared as unconstitutional, we still depend upon the Parliament to rectify. Where are we?
So, Lord, may I venture to suggest that your Lordships have...
Then all the Keshwanand Bharti, they have no relevance then. And the basic structure doctrine has no relevance then.
No, my Lord, the basic structure doctrine, my Lord, with the greatest of respect to this great doctrine that we have developed, my Lord, goes so far as to make a declaration of unconstitutionality. Lord, those are the limits of the basic structure doctrine. But we must also accept the fact that the basic structure doctrine, Lord, in a slightly, it's not an uncharted sea, Lord, as was said in Minerva Mills, in a different context. So, Lord, we accept the fact that powerful as the basic structure doctrine is, it also has some cognate limits. Lord, when we say that this is unconstitutional, the courts intentionally do not say that revive the old. The courts are intentionally silent on that. And, my Lord, they are advisedly so. Because...
What about the observations made in Vaman Rao?
Yes.
Which is a judgment which came later.
Yes.
After Minerva Mills. The author of the judgment is aware of what is stated in Minerva Mills. But nevertheless, there are observations in Vaman Rao. Should those not be read?
So, my lord, the observations in Vaman Rao do present a difficulty. My lord,
So it is with regard to another challenge. But the author of the judgment is aware as to what has happened when Vaman Rao was being delivered vis-a-vis Article 31C.
no, my lady is right. They
Yes.
do present a
Is
difficulty.
there any import from there?
But there is great import,
Yes.
but in one sense, my lord, it could be argued that Vaman Rao is completely against my argument. Vaman Rao shows a consciousness on the part of those judges that in fact the old revived.
Yes.
But my lord, my answer to Vaman Rao is that we must understand the peculiar circumstances in which Vaman Rao moved in lockstep with Minerva Mills. It was not possible for the judges, my lord, in Vaman Rao to actually pass a decision on this aspect because it moved simultaneously along with Minerva
But
Mills.
the judgment actually came later, the reasoning.
It
In
did.
November
It did.
1980.
And your lordship is, my lady is right. And I would venture to suggest Vaman Rao is absolutely correct because it was dealing with a situation till the amendment. So the question in Vaman Rao is till 1976 when the amendment takes place, is it valid or not?
But chronologically, if you see, from the historical perspective,
Yes,
in November 1980,
yes,
this court was aware of what has happened on 31st July 1980.
yes. But there's no running away from that. That is,
Yes,
that is
they have
the,
not shut their eyes to it.
they have not.
Do about it.
Another thing,
It has been
Mr.
read as
Yeah,
together.
Mr. Andar,
Please.
the basic structure doctrine, its strike law doesn't apply to the original provisions of the Constitution.
My lord, only is the
can't-
amendment law.
Right, and there's a reason for it. You can't say that some part of the original provisions of the Constitution are so out of sync with the overall theory of the Constitution as to be violative of the basic structure.
My
In
lord.
other words, however much you find that an original provision of the Constitution is perhaps out of sync with what the other part of the Constitution does, it's not hit by the basic structure. The basic structure doctrine is a limitation only on the amending power, right? Now, actually, the basic structure doctrine is a very curious amalgam of process and substance. It's a limitation on the power to amend the Constitution, which is a processual power. But those limitations are not of a processual character. Those limitations are born from the substantive provisions of the underlying Constitution. That is, you draw those limitations from the substantive provisions of the existing Constitution and read them as limitations on the processual power to amend. Therefore, in that sense, that's how we say that the basic structure doctrine is a limitation on the amending power. If you breach those limitations, the very exercise of the amending power was null and void. It's not a case where a provision which is otherwise inserted into the Constitution is held to constitute a violation of a substantive constitutional safeguard like Article 286, which we saw in Sundaramayyar's case. This is a case where if you breach the basic structure, the very process by which you sought to amend the Constitution stands constitutionally invalidated. In which case, the very act of insertion doesn't see the light of the day.
So, Lord, I see that point, but may I, once again, Lord, attempt to answer it with 2 points. But if your lordship has any other point, I will deal with that. But the first is this, Lord. Your lordship is perfectly correct, Lord. The basic structure, Lord, deals with amendments and the limitation on those amendments. But I would request your lordships to bear in mind that 31C itself came in by way of an amendment.
Right.
So, my lord, it was not, as it were, my lord, originally at inception in the Constitution. So, my lord, the basics.
And therefore, it could be challenged. It was upheld in Keshav.
Your lordship is perfectly right. Exactly the point. It could be challenged. It was upheld in Keshav Nanda Bharti. Now, the second challenge was to this amendment. And therefore, basic structure was correctly deployed, Lord, against the amendment to say, let us test it against the amendment. But when your lordship puts it to me to say that it renders the insertion as if it had never been, in my respectful submission, I would submit this is an extension of the basic structure doctrine. For this reason, Lord, the basic structure doctrine accepts the constituent power of Parliament, 1. Secondly, to your lordship's own point, Lord, it is a self-limiting doctrine. It doesn't go, for example, to the original features of the Constitution. So, Lord, basic powers doctrine, it has limitations. Now, Lord, this question is in one sense a question of where do we draw the line with the limitations of basic power.
But Therefore, to sustain your argument, what we'll have to postulate is this, that though 31C as amended was held to violate the basic structure, the very act of amendment was complete. Once the precedent
That is
had
my
signed.
point. I don't think I could have.
That's right. According to you, the very act of amendment of the Constitution was complete at a formal level, certainly, because Parliament enacted the amendment, it passed the amendment, the President signed the amendment into law, and therefore it took effect. Now, the fact that it took effect and was held to be void is a subsequent event, but it took effect before it was declared as void. That's what we'll have to hold to accept your point.
Yes.
Lord, I think your Lordship has put my point very articulately. But I, for myself, Lord, see no conceptual fallacy in that point. But, and I readily accept, give me a moment to Lord, elaborate on this, that your Lordship's point would be perfectly correct if the procedure of 368(2) remained incomplete. It could never be written into law. Now that, Lord, I respectfully submit is a very important counterfactual indication that we have in the Constitution itself. 368 tells us that in a situation where it's not written into the law, it is not the law, it is set aside, the old law has not been displaced. But we have a constitutional lead in this regard, which is 368(2). It has now been written into the Constitution. Right or wrong, it has been written in. Your Lordship's court with the basic structure doctrine, Lord, has a wide sweep. I accept that. Lord, must be developed and can be developed further. But on its current recognition, in my respectful submission, stops short at this to say that I declare this to be unconstitutional. In these circumstances, Parliament must do its job again. Lord, I find that to be a perfectly harmonious and symmetric reading of the Constitution. In fact, Lord, this doctrine of voidness does great violence, for example, to 368(2).
No, and if Parliament doesn't do that,
But this is exactly the situation we have.
what happens then?
So, Lord, it is ineffective, but it remains on the statute. It is ineffective, but remains on the statute.
So you are there drawing a distinction between the procedure is not followed.
Yes.
Or a situation like ours where the procedure is followed, but after having followed the procedure, the precedent has signed.
But
So according to you, that will not result in the, but then if we, the moment we hold that, we are directly finding fault with the declaration in Minerva. Because the Minerva declaration is only on section 4.
But if your Lordship permit me to say, Lord, the Minerva declaration was flawless. Lord,
You
more
will have to hold that your declaration in Minerva was wrong and you should have invalidated 31C itself,
but Lord,
which nobody has really argued.
but Lord, as I see the order, and that's why I showed your Lordship the order invalidates the amended part of 31C. As I read the order, Lord, it invalidates that amended. Now, Lord, I want to just
The
make
clauses 4 and 5 of Article 368 also was struck down
exactly,
in Minerva.
exactly.
But nevertheless, you see, we have Vaman Rao's observations.
Yes, Lord. So, Lord,
Despite this,
so, Lord, my respectful submission with regard to Vaman Rao is that it should be understood in the limited context in which it was passed and the limited challenge before them, namely up to the date of the amendment. So, Lord, that is how I deal with these 2 points. Now, Lord, I just want to deal with a related aspect, my Lord. It's already dealt with actually. Lord, the argument which is made to say that section 4 of the amending act should somehow be viewed in isolation. Lord, I've already actually said what I want to say on that. But in my respectful submission, that is factually difficult to understand, given the fact that section 4 under 368(2) became a part of the Constitution. It's very difficult to understand how section 4, after that process is complete, can still be regarded as separate and distinct. It has now embedded itself in the Constitution. If you are going to declare section 4 unconstitutional, by any system of logic, what you are effectively doing is rendering a part of the Constitution unconstitutional. So, Lord, this argument in my respectful submission,
Part of the,
Constitution as amended, unconstitutional.
so that's it. You're right. Part of it is okay.
Yes, ma'am.
whereas their argument is it has
That's what they're
not
saying.
entered the Constitution statute at all.
But that I've already said what I did want
You
to
have
say.
said that argument would have been right. According to you, the procedure was not.
Yes,
right.
I would readily concede that. Now, my lord, I move to the third point. My lord, much has been said, and I was trying to deal with it, my lord, when your lordships put it to me twice or thrice, parliamentary intent. So your lordship spoke about parliamentary intent, and one of my learned friends also spoke about that. And the submission was that parliamentary intent could never be to result in such an absurd situation. Your lordship put it to me also, parliamentary intent is relevant. Let us see what is the parliamentary intent. We must have some extrinsic view or material evidence on this. Now, my answer to it is this. Once again, parliamentary intent, I would concede is relevant in this situation where it doesn't come onto the statute book. And one of the cases relied on by the learned Solicitor General, I put it in my note, and I'll just tell your lordship where. Para 20, at page 112 is 112 is exactly this, my lord. This is the State of Maharashtra and Central Province Manganese ore. Exactly this situation where actually there was a problem of procedure. Exactly the situation. In these circumstances, the court said, let's look at intent. It could never have been the intent of Parliament to delete but not to bring about the substitution. And they expressly say, in this case, fortunately, we don't have the present problem because, in fact, it's not substituted in law. Now, my lord, I understand I present your lordships with this problem, but my lord, I, for one, don't see it as a problem, my lord. I see it as the ordinary working of the Constitution, which from time to time hands over the baton for Parliament to do a necessary action. But I find it difficult to conceive how your lordships would say that this is void and that is revived. As your lordship say, parliamentary intent, we must look into these matters. How is it to be decided? But it is best left to Parliament to do its job. And its job is this, that when such a situation arises, it immediately steps in and rectifies. So, Lord, in answer to that, is our judicial review doctrine falling short? Or are we falling short as the judiciary? The answer is no. My lord, the basic structure document has been stretched to the fullest, but it has limits, and now it is for the other arm, Parliament, to step in and take the corrective steps. But that is my respectful response on these aspects of the matter. Now, my lord, I just want to point out to your lordship,
What about, are you going to argue on 39B?
yes, for a few minutes on 39. But can I make two more points on this?
Yes,
and then go?
certainly.
But I understand I'll be keeping your lordship.
No,
Perhaps a little later.
what are the two?
Not too much later. Lord, 2 points I want to make. Lord, the first point I want to make is that in Minerva Mills, Lord, there was a very interesting discussion between the learned Attorney General and the Solicitor General and the court. Lord, they requested the court to actually read down the amendment to its original unamended form. Lord, the court declined to do it.
You have quoted that.
I have quoted that here. And the reason it declined to do it is that, look, the amendment, by reading it down, is being made something it is not. In fact, it is the very opposite of what you have done by way of the amendment.
They also cite the Law Minister's statement in Parliament.
Your lordship is right.
The reason why we wanted to amend it was we wanted laws to be saved without the let or hindrance of the fundamental rights.
I am obliged, your lordship.
That's what the Law Minister said.
I am obliged, your lordship. Now, Lord, not in the
Paragraph 15 minutes.
So, Lord, the result which could have been obtained by another method, you read it down, was expressly declined by the court. They said we can't do that because that was another way of achieving this very method that the unamended 31C survived.
Quickly read both the paragraphs.
Please.
64, 65.
Please.
There
We
you know,
expected you to read 15 minutes before.
page 5 of your.
But yes, paragraph 11.
So as to understand whether your interpretation as propounded in para 12 is correct or not.
But please allow me. What the learned, if your lordship follows that.
Yes.
What the learned Attorney General and learned Solicitor General strongly impressed upon us that Article 31C should be read down as to save it from the challenge of
Because one of your submissions is don't go by the operative part of Minerva. Don't just go by the declaration. If you read declaration alone, perhaps, as my esteemed sister said, Vaman Rao it will spoil the show.
Well,
But try to read 64,
I'm obliged,
65 and then reconcile.
I'm obliged. Lord 64. Lord, the learned Attorney General and learned Solicitor General strongly impressed upon us that Article 31C should be read down so as to save it from the challenge of unconstitutionality. It was urged that it would be legitimate to read into article the intendment that only such laws would be immunized from the challenge under 14 and 19 as do not damage or destroy the basic structure of the Constitution. The principle of reading down provisions of law for the purpose of saving it from a constitutional challenge is well known, but we find it impossible to accept the contention of the learned counsel in this behalf, because to do so will involve a gross distortion of the principle of reading down, depriving that doctrine of its only or true rationale when the words of with are used inadvertently. The device of reading down is not to be restored to in order to save resorted to, but I'm so sorry. No, not to be resorted to in order to save the susceptibilities of lawmakers, nor indeed to imagine a law of one's liking to have been passed. One must at least take the parliament at its word when especially it undertakes a constitutional.
Now 65.
Now, but Mr. Pardiwala read out to us an extract from the speech of the then law minister, who, while speaking on the amendment to Article 31C, said that the amendment was being introduced because the government did not want the let and hindrance of fundamental rights. If Parliament has manifested a clear intention to exercise an unlimited power, it is impermissible to read down the amplitude of that power so as to make it limited. The principle of reading down cannot be invoked or applied in opposition to the clear intention of legislature. We suppose that in the history of constitutional law, no constitutional amendment has ever been read down to mean the exact opposite of what it says and intends. In fact, to accept the argument that we should read down Article 31C.
Now this is important. So as to make it conform to the ratio of the majority decision in Peshwan and Bharti is to destroy the avowed purpose of Article 31C as indicated by the very heading saving of certain laws under Articles 31A, 31B and 31C are grouped. Now read further.
Obliged, Lordship. Since the amendment to Article 31C was unquestionably made with a view to empowering the legislatures to pass laws of a particular description, even if those laws violate the discipline of 14 and 19, it seems to us impossible to hold that we should still save Article 31C from the challenge of unconstitutionality by reading into that article words which destroy the rationale of that article and an intendment which is plainly contrary to its proclaimed purpose.
Now para 12 is your interpretation,
Yes,
right?
or I hope it.
Even if we accept it, you will have to still overcome Vaman Rao.
Yes,
So first hurdle, you have to overcome this.
Yes.
Vaman Rao.
From the aforesaid,
Yes, but from the aforesaid, it is evident that Chief Justice Chandrachud expressly declined the suggestion by the learned Attorney General and learned Solicitor General to read down Article 31C to save it from being declared unconstitutional. The reasons in paragraph 65, namely to accept the suggestion and argument of reading down so that it would conform with the ratio of the majority decision in Keshavananda Bharati, is to destroy the above purpose of 31C as amended, indicated by the very head saving of certain laws, makes it evident that Chief Justice Chandrachud declined the suggestion that the statute should be read down to its unamended form.
arguing
Lord, to my Lord Justice Pardiwala's point, Lord, I've already said two things with regard to Vaman Rao. Lord, one, the circumstances in which it were passed. The second, the fact that it was dealing with a pre-amendment situation. And perhaps the third is that they were two.
So your argument is that Minerva Mills merely struck down section 4.
Absolutely.
That it merely struck down section 4 to be unconstitutional, but the entire 31C as amended.
The amended part stands struck down. That is my argument precisely. But it is not the entire 31, because 31, of course, was the subject matter of Kesav Nanda Bharti. So, my Lord, it is the amended portion
Then
which
we are
stands
again
struck down.
back to square one. Then we have to only read the operative part of Minerva. There is inconsistency in your submission.
Which means 39, B and C also go. That's logically.
To be precise, come to para 15 quickly.
And if 39, B and C also goes, what is the purpose of 31C?
This is what you are trying to drive.
But may I come to your Lordship in just a minute? Just a minute.
Para 15.
Please.
The argument that the order and judgment in Minerva Mills merely struck down section 4 to be
Yes,
unconstitutional.
that is what I said.
Article 31C as amended by section is stated to be rejected.
No, your Lordship is right, my Lord. So, my Lord, I do say that Article 31C as amended has been struck down. No, no, my Lord, the problem, of course, my Lord, which stares all of us in the face is Keshav Nanda.
Yes, that's.
It is, so my Lord, there are two ways of viewing it, to be fair. My Lord, one is, my Lord, irrespective of Keshav Nanda Bharti, 31C is struck down. The other is that the amendment in 31C is struck down. There are two ways of viewing the problem. There are two ways of viewing the problem. It is a difficult conceptual problem, but my Lord, it is there. It requires to be solved by our lordships. Now, my Lord, I just want to say two or three more things on 31C, if your lordships will permit me. Well, the NJAC judgment in 2 minutes.
Yeah.
The NJAC judgment.
That's the problem we have to solve it.
But I do hope I can assist your lordship in a few minutes with that. Not the NJAC judgment. Not my short point on the NJAC judgment is this. Lord, it is only Justice Kehar who grapples with the doctrine of revival. Point number one. Lord, the other two learned judges, Justice Kurian and Justice Goyal, will not say that of course it must be so, but they don't actually grapple with the doctrine. So, Lord, there is no reasoning with the doctrine of revival. Justice Chalmeshwar dissents, and Justice Lokur expressly says that I want to leave the question open. So, Lord, in my respectful submission, there are 2 or 3 points that emerge. The first is this, that there is no discernible ratio from the NJAC judgment. To read a single judgment in this regard, in my respectful submission.
Music to the solicitors, yes.
No, but on this aspect, or only on this aspect.
Well, if that line comes in 9 judgment on the lighter side.
On this aspect, Lord, of revival, Lord, it has no precedential value. That is the first. The second, Lord, of course, that your lordships put to me and immediately notice, the 99th amendment is not a case of substitution. It's a case of supersession, which has also been noticed in the Zail Singh case, which my lady put to me. And the substitutions which were made were merely of a consequential nature, but it was an entire independent scheme which was being put in place. So it was actually a supersession, a distinction noted in law, noted by Zail Singh's case, noted by other cases, etc. And it is not a case of a substitution. So that is what I wanted to tell your lordship very briefly with regard to the NJAC judgment. Lord, just to conclude the 31C point, my lord. Lord, everything I have said Lord, does not result in a constitutional vacuum. It does not result in a constitutional crisis. I take your lordships back to the words of Minerva Mills, where the learned Chief Justice, Justice Chandrachud, said that if the pith and substance of 39B is what the law is about, we have no fear of a challenge from 14 and 19. And Lord, the third point I leave your lordships with is that Lord, there are some possible problems with the Coelho judgment, with Article 31C, Lord, about what is the effect now of the remaining part of 31C, given the fact that 14 and 19 have now been defined as being part of the basic structure. But it is best that Parliament should re-legislate on this aspect. So, Lord, that is what I wanted to say with regard to 31C. Now, Lord, a few minutes, if your lordships would, Lord, indulge me, Lord, on the second aspect, Lord, which is the 39B aspect. But may I?
Yes.
Lord, 39B, first point, Lord, is can we say that the judgment in Mafatlal is actually obiter? Lord, my learned friend, the Solicitor General, did forcefully argue that, in fact, it was noticed and applied, and therefore it cannot be obiter.
It is discussed and applied.
But in my respectful submission, Lord, the question is whether it is obiter on this point. The point that we are discussing is whether private interests should be included within 39B. On that, it was a passing reference, merely saying that Ranganath Reddy onwards has recognized it to be so. Yes, it is true that it was then accepted as true and applied, but as far as this point is concerned, it was certainly obiter. So, Lord, it was applied in the context, as your lordship knows, of the tax which was already collected. And the question is, do you give it back to the assessee when the assessee is already passed on the burden to the customer? Or do we then distribute it for the purpose of 39B? So there was no decision on this aspect of the matter in Mafatlal. In my respectful submission, obiter it is. Now, Lord, I have got late in the day, but upon having the benefit of your lordship's points, Lord, and heard my learned friends, Lord, I want to suggest to your lordship that the problem with regard to 39B may not be such an insuperable problem. Now, Lord, I tell your lordship why. Your lordships are fully aware that there are powers of acquisition of private property. Lord, the power to make that law is under 246, read with the relevant entries in the lists. But if I'm not wrong, list 318 or something of list 3 provides for the power of acquisition.
Entry 42, actually, 42 of list 3, acquisitioning and requisitioning of property. Entry 42.
Sorry, Manoj. But it is definitely a power which can result in a law with regard to acquisition. Now, Lord, the suggestion that was made by some of my learned friends to say that 39B is the power to acquire, I respectfully submit is not correct. 39B is the policy that the state has to work to secure towards. It is a statement of policy which is contemplated in 39B. The Constitution has other powers which provide for acquisition. Now, Lord, my proposition to your lordship is this, that if there is a policy which requires the acquisition of private interests, which is done in accordance with the powers of acquisition, the problem solves itself. But in this sense, that 39B at the end of the day is a policy statement. We must work towards the policy of a distribution of ownership and control of the material resources of the community. 39B by itself does not have the power of acquisition. The power of acquisition is 300A elsewhere. Once it is acquired under the provisions of 300A, the issue does not survive. So, Lord, the issue in one sense translates to this: will you acquire for no value, or will you acquire on the principles of 300A following the due process of law? But if that is there, the question doesn't arise. So, when I request your lordships to consider this.
39B and C also not comprehend a law. I mean, it's not a power. No, part 4 is
may-
not a power at all.
No, they may-
Part 4 is only an object. It's hortatory as
The
we call
goal.
it. It's a goal. But when Article 39B says that the ownership and control, the state shall secure its policy towards securing that the ownership and control of the material resources of the community shall be so distributed to so as to subserve the common good.
Yes, Lord.
Does this not also factor in the reasonableness of a law which also provides for acquisition so that you will distribute?
No, Lord, I would readily agree with your
It
lordship.
would be very technical to say that this does not allow the state to justify a law of acquisition on the ground that what this contemplates is only distribution of what you already have.
No, Lord, I would respectfully agree with your lordship. Lord, I think that would be an over-technical view, and that is not a submission I make. But Lord, the point that I do wish to make to your lordships is that the problem with regard to private interest, that part of the problem with 39B is solved elsewhere through the constitutional mechanism, through the power of acquisition. If there is a policy and the policy translates into a law which is made under the legitimate use of 246 towards the pith and substance of 39B, adhering to all the principles of acquisition, the question does not arise.
And
But-
if there is an acquisition, it would squarely come within the concept of material resources of the community.
Yes, now, but I'm just going to address
Because that is going to be distributed for the common good.
But yes, but so I'm just going to come
Here
to
it
that in a
is
minute.
distribution from A to B. That is your case.
That is, once again, my lady has hit it on its nail, because, my lord, I also have put one part about the limits of this doctrine. And my lord, perhaps the most enthusiastic proponent of this document, Justice Krishna Iyer himself, in Bhim Singh Ji says that the limits of this doctrine are reached when you try to distribute from private party A to private party B. And that is actually what we are concerned with in the challenge.
But that is not the question before us.
Yes, that is not a question before your lordships. I quite see. But not in trying to assist your lordship on what we should do and what we should say with regard to 39B. I wanted to point out to your lordships, or 2 or 3 things in my note, but I do want to indicate the outer boundaries of this document.
Yes.
What the outer boundary of this document is, it does not contemplate an exchange of these material resources between 2 sets of private individuals. No, that my learned friends hasten to add is the only question. It's the only question in the challenge which will now take place after your lordship send it down to an appropriate bench. Yes, of course it is.
That may also not be strictly correct. The idea is sometimes you are redistributing wealth from those who have a monopoly over wealth. That's what you did that's what our land reform laws did, to redistribute wealth from the zamindars to the tillers. So it was really from one set of private individuals to another.
Well, or once again, you were, no, once again. But your lordship's point is very well taken, my lord. And but the only thing I would add to that is, my lord, those acquisitions were done pursuant to the power to acquire under the constitution and for a particular purpose, agrarian reform, which is now well known. So 31A, 31B and 31C really can be fully understood if we read them together. But I do accept that, and Lord, that is a part of my note. Could I just read now 4 or 5 paragraphs of my note, and I am done.
Under those laws of agrarian reform, all these lands first stood vested in the state. It became community resource. Then the tiller had to file an application seeking occupancy right. And if he is really the tiller, then order is passed by the land tribunal to give it to the
I
tiller.
am deeply obliged to my lady.
And not directly to the tiller.
Exactly the point I want to make with regard to acquisition. That actually it is not such a problem if we intersperse the concept of acquisition. Lord, this argument which has been made thus far on my part as well, Lord, has left out that part. Lord, it is important to understand this directive principle in the context of the power to acquire. Under 300. Now, Lord, I have kept your lordship so long, Lord. Can I just show your lordship, Lord, 4 or 5 paragraphs and I'm done, Lord, with this note.
Yes.
But may I take your lordship, Lord, to my note at page, just to indicate at page 124, Now at 124, in the first 3 paragraphs, I've dealt with the Mafatlal judgment. But there I've made the point that I have made to your lordships with regard to obiter. I sought to make a second point also, that the judgment is totally distinguishable. But it deals with unjust enrichment and the distribution of tax. So it is totally different. But in my respectful submission, the reference was rightly made and your lordship ought to entertain it. Now, Lord, the second set of points, 4 and 5, Lord, is what I have said with regard to 300A. If I can just read my formulation in paragraph 5.
Yes.
Once the property is acquired with the authority of law, the question with regard to the inclusion of private property within the sweep of 39B falls away. The petitioner submits that the acquisition with the authority of law of private property may be pursuant to a policy formulated by the state under 39B, to my lord's point, and the distribution of ownership and control thereof may be in accordance with the principles of Article 39B. Now, Lord, some suggestions to your lordship about how we will deal with the observations on 39B, I have sought to make here. Your lordships may consider them. The debates of the Constituent Assembly with regard to 39B make it evident that the language of the articles in Part 4 was deliberately drafted to ensure they were not given a fixed or rigid form, but could be fundamentally changing, having regard to the circumstances of the time. Lord, I refer to the speech of Mr. Ambedkar. But it is relevant that the Constitution also provided for fundamental right of ownership to property, Article 19(1)(f) and 31 at its inception. The Constituent Assembly was therefore fully conscious of the fact that private ownership of property was then a fundamental right. As is well settled, it is also a part of the constitutional scheme that the fundamental rights and directive principles of state policy were to be balanced against each other. But Minerva Mills. Despite the socialist aims of the Constituent Assembly in incorporating the directive principles in Part Roman 4, private property was also respected as a fundamental right. Article 39B provides for the distribution as best to subserve the common good of ownership and control of material resources of the community. The expression material resource of the community, now this I want to stress, is a composite expression, and each word is a necessary ingredient of the same. To determine if the requirements are met, it is necessary to consider each of the ingredients being met individually and in the aggregate. That's paragraph 9. But paragraph 10. The expression, so it is necessary to meet each of the conditions individually, but also in the aggregate. So it is a self-limiting provision in one sense. It is very difficult to find something which meets each of the criteria in aggregate, all of them, not and or not one of them, but each of them for every part of this particular Article 39B. Not the expression para 10. The expression material resources of the community must also be in accordance with the intentions expressed by the members of the Constituent Assembly, be interpreted not in a fixed or rigid form, but in a manner which is fundamentally changing. Now, about my submissions. Well, it is submitted that 39B has been deliberately given the language that it has to maintain its open texture, to give it flexibility, to adapt to changing constitutional and social values. But keeping with the spirit of the Constituent Assembly and the manner in which 39B has been drafted, it ought not to be limited and stroke or straitjacketed and stroke or canalized. It is preferable to test each individual case against the ingredients of 39B, keeping in mind current constitutional and social values, not to give a particular temporal interpretation to the article. Current constitutional and social values, i.e. the importance of private property, my Lord the Chief Justice said repeatedly, enshrined in 300A, and the importance to the role of private enterprises, my Lady Nagarathna referred to it repeatedly. The sweep of Article 39B provides that the distribution must be to best serve the common good of all. All of these considerations must be cumulatively considered on a case-to-case basis, but the aspect of community was repeatedly stressed by my Lord the Chief Justice, by my Lord Justice Dhulia, repeatedly, that it has to have a community element to this. The limits of 39B may also be borne in mind. Justice Krishna Iyer himself in Bhimji Singh's case stated that the whole story of Agarwal, Ms. Jetmalani, and Ms. Bisni are a part of the team, Lord, who worked very hard on this. My learned solicitors, Lord, Mr. Jadeja and Mr. Unikrishna, and of course, Lord, my learned seniors, who your lordship will.
Thank you. Please give our
I'm deeply
compliments to
obliged.
the entire team of your juniors who worked very hard.
Deeply obliged to your lordship, Lord. It's been a great privilege for us.
That's it.
Please.
My lord's permitted one, sorry, second, can I?
1 second, my learned brother.
That's it.
No, Mr. Andharjun,
Please.
I think you are leaving for Mumbai today, right?
But I don't have to, if your lordships want me to.
No, no. In fact, perhaps when you go back home, you have young children,
I do, madam.
all right, they might ask you, Papa, what were you doing in Delhi? Right, so you will say that I have gone and argued a case. So the children is curious, might say, what was the case all about? You can't be talking to him or her, 31C, 39B. You will say that we are discussing a case which relate to cheese. The other side, the uncle from another uncle was saying that the cheese had sweet cheese, it had holes. I was saying that it was a Amul cheese which does not have holes.
Lord, I take your lordship's declaratory point on this, Lord, and I will treat it very seriously. I'm deeply obliged to you.
Well,
Let's
yeah, I,
request a clarification. Petition 660 and other petitions related to Rent Act, we're also on board, my lord. Just like to know.
We are going to answer the point of reference.
right.
With a bench of 9 judges, and thereafter it will be placed before the regular bench for hearing the challenges.
Could I make a small prayer, my lord? I not done before constitution. But given the fact that these have been languishing from 92, my lord, till today, and they're still getting 1940.
After the reference is disposed of, you can move the Chief Justice in the administrative capacity, and the matters will be listed assigned to the regular 2-judge or 3-judge bench as the case may be.
If I wanted, my lord's
It will
permits,
have to go before a regular bench, right? 3-judge bench, doesn't have to then go before a 5-judge.
Yes.
lordship, I wanted 1 minute of my lord's time, if my lord's permits. There's a note 1I. I just wanted to point out what are the 4 points I've made. I'm not going to argue them, but just to place them. One, my lords, on 31C we made, I've described, etc., and given details. That was a short, so to say, departure of the balance between part 3 and part 4. From 1971 to 80, 71, 31C came in, and 1980 it was declared void. So there is no vacuum or void. It was for a very short period of 9 years that it survived. Then on 39B, I have also given the rules of interpretation of constitution, harmonious construction, etc. I just want to make one last point, and that's I'll close at that. I've described all this interpretation of 39B, but what 39B says is so distributed. It doesn't say distributed. Now, so distributed, as many of my lords mentioned, for example, airwaves. Airwaves, only 2 players is for the common good. Electricity, sometimes a monopoly is for common good. In some cases, it is many. So distributed is not what the respondents argued, namely give it to everybody.
No,
You can't. So therefore,
argue that at
you
all.
have to see what is in public interest,
You
and
can't
therefore,
distribute. I mean, these are, the
Lordship.
spectrum has to be necessarily, it's
Lordship.
always.
Absolutely.
There are 2
Facts
players.
and
And
context.
therefore, in my note, I've given using the rules of interpretation of a constitution, I've given my submissions on 39B. And
Plus, we just wanted to seek indulgence.
That's-
That's for
and
2 minutes to.
My lord's
make
kind
us-
permission, my lord, the community should be assigned some meaning in the sense, a group of persons who do not have potential other than the policy of the government. And one thing, that by the time the Birla mill and the Vaman Rao were pending, 44.
Then what do you have to say?
Well, we just wanted to point out one important phase. There is a comparative constitutional law question also involved here, Millets, because the original Irish constitution from which we have taken Article 39B has a near identical provision, Millets, and that has been interpreted by the Supreme Court of Ireland by giving reference to our provisions also, Millets, and that is quoted at my volume 2P for your lordship's consideration. And Millets, the second part of it is under 2T, T for technology, where Millets, I have only requested your lordships to keep the expression as fluid as possible because of the changing dimensions of technology. Namely, Millets, there could be an open source. There could be a specific, there has been 100% FDI investment in space. And very recently, the first private satellite has gone out. So there could be mapping constraints. There could be constraints in respect of finding out as to the crop rotation schemes, etc. So that particular information which is tabulated by the satellite also, so over that, perhaps the government might want to exercise control at some point of time for the purposes of distribution in order to facilitate the farmers to know as to how exactly the crop functions or whether there would be a monsoon, etc., etc. So the scope and the width.
2B, right? 2B.
The first is 2P, P for preamble, and the second is
2T.
The second is 2T, which is what technology. I am Nipun Saxena.
So, my lord, may I say a few words?
2P.
2P, P for preamble, and 2T.
And 2P for.
And 2T. I'm so.
So, my lord, may I conclude by one word? The impact of the Minerva Bill and the amendment of Keshwanand Bharti, the speciality attached, the saving or the immunity was taken away, and it became reduced to a normal directive principle of state policy, which cannot give a better right to the government. That remains, and lastly, one judgment of Justice B.V. Nagarathna, 2023. No.
With Justice Joseph, right?
Yeah, with Justice Joseph.
That's been
Lord, if my submission.
That has been, and now lastly, what I say.
2C and 2J, my lord.
2C and 2J.
2C. By Varun Chopra, my lord.
This will load by tomorrow.
Yes, sir. Thank you to all of you, and we thank you very much for all your assistance.
I'm so grateful. We have completed our hearing before dynamic and young Chief Justice.
All of you. Mr. Shankar, as usual, for all your very comprehensive.
As usual, State of West Bengal.
Mr. Compliment.
What?
They have argued before a dynamic and.
We have argued before on the dynamic and young Chief Justice. That stands for D and Y. Grateful.